Good morning, good afternoon, and good evening. Welcome to Course 8 of the Monique and Roland Weil People's Academy of International Law. I am Marjorie Cohn, Dean of the People's Academy, and a member of the Bureau of the International Association of Democratic Lawyers. Our topic for today is the International Criminal Court and prospects for justice and accountability. The International Criminal Court's issuance of arrest warrants for Israeli Prime Minister Benjamin Netanyahu and former Defense Minister Yoav Gallant for war crimes and crimes against humanity is historic. This is the first time the ICC has issued warrants for an Israeli official, and it was only the second time in its 22 years of existence that the ICC issued a warrant for an individual who is not from the African continent. The ICC has since issued an arrest warrant for former Philippine President Rodrigo Duterte for a crime against humanity. The ICC can take jurisdiction over a national of a non-party state if they commit a crime in a state party's territory. But the ICC's jurisdictional scheme for the crime of aggression is much more restrictive than its regime for punishing the other crimes under the Rome Statute: genocide, war crimes, and crimes against humanity. The ICC opened for business in 2002, following 50 years of development. After the establishment of temporary criminal tribunals, limited in time and geography, the creation of the ICC reflected the need for a permanent criminal tribunal. The court's Rome Statute contains checks and balances designed to ensure fairness. The 18 judges are elected by the member states. The powers of the prosecutor are well regulated. Cases can be referred to the court by the UN Security Council or individual member countries or the court's prosecutor. Referrals under the second track are subject to the principle of complementarity, wherein the court would be a last resort only when a state cannot or will not prosecute one of its nationals. The statute contains Miranda-type warnings, the rights to a speedy and public trial, defense counsel, reciprocal discovery, confrontation of witnesses, and protection against double jeopardy. The United States has a history of undermining the ICC. Although President Bill Clinton signed the Rome Statute as he left office, the U.S. never ratified it. In an unprecedented move, President George W. Bush withdrew the U.S.'s signature from the statute in 2002. In 2003, the Bush administration enacted the American Servicemen's Members Protection Act, also known as the Hague Invasion Act. It says that if a U.S. or allied national is detained by the ICC in The Hague, Netherlands, the U.S. military can use armed force to extricate them. This would apply to the close U.S. ally, Israel. The Bush administration also effectively blackmailed 100 countries that were parties to the Rome Statute by forcing them to sign so-called bilateral immunity agreements in which they promised not to turn over U.S. persons to the ICC, or the U.S. would withhold foreign aid from them. Both of Donald Trump's administrations imposed sanctions on the ICC for investigating U.S. and Israeli leaders. On June 5th, the U.S. State Department imposed sanctions on 4 individuals currently serving as judges on the ICC for their involvement with the ICC's investigations into the U.S. and Israel. This course will explore the functioning of the ICC and examine its effectiveness in bringing those who commit the worst atrocities to justice. It will cover the challenges that victims of Israel's genocide in Gaza and former Filipino President Rodrigo Duterte's vicious war on drugs face in presenting evidence to the court. And it will analyze the legitimacy of the ICC's jurisprudential system. Our faculty for this seminar includes Triestino Mariniello, Kristina, Conti, and Beth Lyons. Each of them will speak for about 40 minutes. They will then comment on each other's presentations, followed by questions and answers with the registrants. We have French, Spanish, and English translation. And there's a little box at the bottom of your screen marked interpretation. You click on your language, and then you will hear it interpreted into that language. Please put your questions in the Q&A box for our discussion following the presentations. In the next few days, we will post the faculty presentations in English, French, and Spanish on our website, peoplesacademy.net. And so, who are the members of our esteemed faculty? Maria Kristina Conti is a people's lawyer in the Philippines. She is currently Secretary General of the chapter of the National Union of People's Lawyers in the National Capital Region, NUPL-NCR. She has 10 years of experience as a litigator and 25 years as an activist, serving in grassroots and non-governmental organizations. Core to her work is combating impunity through strategic human rights litigation. At present, Kristina represents victims of extrajudicial killings and other rights violations in the war on drugs of the former president, Rodrigo Duterte. She is registered as assistant counsel at the ICC in anticipation of the trial against Duterte. She has a broad background in legal advocacy in public interest cases, in situations of political persecution, law enforcement, and prison reform, conflict resolution, and peace processes, and free speech cases. She lectures on media law at the University of the Philippines. Kristina holds degrees from the National University's College of Media and Communication and the College of Law. Kristina will discuss the court on trial, jurisdictional and enforcement issues in the case of Duterte and the situation in the Philippines. Also, a member of our faculty is Triestino Mariniello, who is a full professor of law at Liverpool John Moores University in the UK and a member of the legal team for Gaza victims before the ICC. He is an Alexander von Humboldt alumni at the Humboldt University of Berlin. He has served as associate legal officer at the ICC, working on the situations in Sudan, Kenya, and the Democratic Republic of Congo. Triestino's research interests focus on international criminal law, international humanitarian law, and international human rights law. His academic writing has appeared in a variety of leading journals in international criminal law. Triestino will discuss the Palestine situation before the International Criminal Court, prospects and challenges. Our third faculty member is Beth Lyons. Beth is an international criminal defense and human rights lawyer. She is currently a co-counsel for Mr. Dominique Ongwen at the ICC and author of the newly published book, Race, Culture, and Mental Illness in the International Criminal Court's Ongwen Judgment, Biases and Blind Spots, which was just published by Palgrave Macmillan. Beth has represented clients at the International Criminal Tribunal for Rwanda as well, including Major F.X. Nzuwankame, the military coup case, for whom she and lead counsel Chief Charles Taku with the defense team won an acquittal on an appeal in 2014. And I want to remind those of you who have been following our programs that Chief Taku was a presenter in one of our prior programs. But Major Nzuwaneme is still not free. Since 2014, he has been illegally detained, first in a safe house in Arusha, Tanzania, and currently in Niamey, Republic of Niger. In 2025, he completed the 20-year sentence, which was originally imposed by the ICTR trial chamber, plus 5 additional years for crimes for which he was acquitted on appeal. Beth is a former legal aid attorney in New York City. Since 1997, she has served as an alternate delegate to the UN in New York on behalf of the International Association of Democratic Lawyers. Using the lens of the ICC's Ongwen judgment, Beth will examine the racial and cultural biases and blind spots in the ICC's jurisprudence, which, in her view, undermines the court's legitimacy and negatively impacts international justice. So we will begin our program with Triestino Mariniello. Triestino?
First of all, many thanks for the invitation. I'm very happy to be with all of you today. Well, good evening, good afternoon, or good morning, depending on where you are. So in my 40 minutes, I'm going to provide a brief presentation about a general overview about the International Criminal Court. I realize that not everyone has a background in international criminal law, so maybe giving some information on the most important elements characterizing the establishment and the work of the International Criminal Court may be important. Then, after a few minutes, I will move according to the title of my presentation to discuss the Palestine situation, or to say it better, the situation in the state of Palestine before the International Criminal Court. I will try to provide a reconstruction of this situation, because in contrast to what a lot of people say and believe, the Palestine situation before the ICC has not started after the 7th of October 2023, but it goes back to early 2009. So in these 40 minutes, as I said, I will try to provide also a critical reconstruction of this situation, which actually has been open now more than 16 years ago, to see where we started, what happened in these 16 years, which have been the most important developments, and where in particular we are today. So the International Criminal Court, or ICC as we will call it today, is the first permanent international criminal tribunal. Permanent means, first of all, that has not been created to deal with a specific situation, like it was before, for instance, in relation to the International Criminal Tribunal for the former Yugoslavia, or the International Criminal Tribunal for Rwanda, created by the Security Council in order to deal with a specific context, with international crimes committed in these specific situations. The International Criminal Court has potentially, but only potentially, universal jurisdiction, which means it might deal with international crimes committed in every part of the world. It has been created in Rome in 1998, but as it has been said before, it started to work only in July of 2002. Why? Because at the time, 60 states, 60, ratified the statute of the International Criminal Court, and so it became effective on the 4th of July 2002. The International Criminal Court is created with a clear jurisdiction. Jurisdiction, first of all, means material jurisdiction. Material jurisdiction means that the court has competence over genocide, the crime of genocide, crimes against humanity, war crimes, and potentially, when some conditions are met, the crime of aggression. But only committed, and that's the temporal jurisdiction, after the entry into force of the Rome Statute, so not before July 2002, and committed after a state has ratified the Statute of the International Criminal Court. The ICC has personal jurisdiction, which means that it deals only with individuals, only with individual criminal responsibility. Generally, we can see on the media, and that's not correct, that a state, the state of Israel or Russia, and the list is long, is tried before the International Criminal Court. That is legally wrong. The ICC does not have any competence over state responsibility. For this, there is the maximum judicial body of the United Nations, which is the International Court of Justice, or ICJ, as we will call it today, and emphasize the difference between these two bodies is crucial. The ICC, again, to make it clear, does not deal with state responsibility, but only with individuals accused of war crimes, crimes against humanity, genocide, and potentially crime of aggression, while the International Court of Justice deals with state responsibility. Formally, the International Criminal Court is not a UN tribunal, is not an UN organization. It has relationship with the United Nations systems in some particular cases, but it's independent. It's been created by the states, not by an international organization like it was for the ICTY and the ICTR. So it's the first time in the history that states have decided to reduce their competence in criminal justice affairs, to reduce their sovereignty in relation to the exercise of their power in the field of criminal law, in particular of international criminal law. The ICC has jurisdiction only as a general rule, but there is an important exception, when international crimes are committed by nationals of a state party, which means a state that has decided to ratify the Rome Statute of the ICC. At the moment, this decision has been taken by 125 states. The last one has been in January, Ukraine. The ICC has jurisdiction, so when crimes are committed, one of these crimes is committed on the territory of a state party by anyone, or by nationals of a state party. Just to give some examples, the ICC has jurisdiction over US nationals for war crimes, for instance, committed within the context of the war in Afghanistan, because Afghanistan is a state party to the International Criminal Court. The ICC does not have jurisdiction over US nationals for war crimes committed in Iraq within the context of the war in Iraq, because US has not ratified the Rome Statute and because Iraq has not ratified the Rome Statute. So these are the two jurisdictional conditions: competence over crimes committed by nationals of a state party or on the territory of a state party. This is extremely important and crucial also in relation to the situation we are discussing today, the situation in the state of Palestine. As I said, there is an exception in relation with this, and it's when the referral, so the jurisdiction of the ICC, is activated or triggered by the Security Council. The court is not a UN organization, but the Rome Statute recognizes, for instance, the role of the Security Council as the main actor at an international level in restoring and maintaining the peace under the UN Charter. So the Security Council may refer a specific situation to the ICC, like it happened in Sudan, in relation to the situation in Darfur, a region of Sudan, or like it happened in Libya since 2011. So both of them, Libya and Sudan, have not ratified the Rome Statute. But the ICC has jurisdiction over crimes committed on the territory of these two countries because the Security Council has referred the situation in this context to the International Criminal Court. Syria is not a state party to the International Criminal Court. The Security Council has tried to refer the situation in Syria, but it has been stopped by the use of veto powers by some permanent states. Which is the outcome of this? That the court does not have any jurisdiction, cannot exercise its jurisdiction over international crimes allegedly committed on the territory of Syria or by Syrian nationals. One of the most important aspects, one of the pillars of the International Criminal Court is the so-called complementarity principle. Complementarity means that in contrast to the ICTY and ICTR, states still have primary jurisdiction. The court can intervene only when states fail to exercise jurisdiction over international crimes falling within the jurisdiction of the International Criminal Court. The ICC can intervene only when states are unwilling or unable to carry out, under Article 17 of the Rome Statute, genuine investigations. It will take time to explain the complementarity principle. If there are any questions, we can go for sure back to it. But what is important now to stress is that this is a last resort court. Last resort means that The Hague intervenes here only if states are unwilling or unable, or according to the ICC jurisprudence, all states are inactive. In other words, states are not putting in place at all any investigation. So if there is no investigation concerning the same individual and the same person under the attention of the International Criminal Court, that's the only case in which the ICC can intervene. If a state that has primary jurisdiction is investigating the same person for the same crime, in that case, the specific case against that person will be not admissible before the ICC. And that's also one of the arguments raised by Israel. But we will come back to this. So, after this brief overview, there will be a lot to say. We can come back, of course, if there are any questions. Let's just move to the specific situation before the International Criminal Court, which is the situation in the state of Palestine before the ICC. So, the current the relationship between Palestine and the ICC started in early 2009. Why? Because there was a military operation at the time, which was called Castlet, another military operation in the Gaza Strip, which caused the death of thousands of civilians at the time, and a long list of war crimes and crimes against humanity committed against the civilian population in Gaza at the time. Widely documented also by international organizations, including UN independent commissions of inquiry. One of you will remember the famous Goldstone report, the report of a UN Commission of Inquiry, which concluded that the Israeli authorities, among others, had committed war crimes in the Gaza Strip during the military operation Castlet. So after this military operation, Palestine accepted, under Article 12.3 of the Rome Statute, the jurisdiction of the International Criminal Court. That's another important procedure we should introduce. Every state can accept with retroactive effects the jurisdiction without becoming a state party, without ratifying the statute of the ICC. That's exactly also what Ukraine has done before ratifying the statute of the International Criminal Court. So, early 2009, 2012, it took to the first prosecutor of the International Criminal Court to issue a two-page decision in which the prosecutor, after a preliminary investigation, decided not to open an official investigation. The prosecutor at the time, the Argentinian lawyer Luis Moreno Campo, actually said that he didn't know whether Palestine was or not a state under the statute of the International Criminal Court. And for this reason, very surprisingly, I should say, he decided to refer this question to political bodies, not to the competent trial chamber, as it will happen later, and we will come back to this, but to the General Assembly of the United Nations and to the Assembly of State Parties of the International Criminal Court. So the prosecutor actually decided not to decide. It took 3 years to issue two-page decision, as I said, in which the prosecutor, despite, he said, he had evidence that war crimes had been committed during the military operation Castellet, but without being certain about Palestine statehood, one of the preconditions for the court to exercise its jurisdiction, decided not to open an investigation. Actually, the General Assembly, at the end of that year, 2012, took a decision, supported by an incredible majority of states sitting in the General Assembly, 139 states, that confirmed the statehood of Palestine. But despite this decision of the General Assembly, the prosecutor never went back, at the end never opened an investigation. The outcome of this is very simple. No victim of that military operation has never seen any form of justice before the International Criminal Court, because there has never been an investigation, because individuals responsible for those crimes have never been held accountable. Then, after very few years, there was another situation which was not directly regarding, let's say, the situation in Palestine, but indirectly, yes, the so-called flotilla incidents, when the IDF, the Israeli Defense Forces, attacked the so-called Mari Marmara, so boats that were trying, something we have seen also happening just a few days ago, to break the siege established by the Israeli Authority over the Gaza Strip. The IDF intervened in international waters, Turkish activists were killed, a preliminary investigation was opened by the Office of the Prosecutor. It was concluded after a few years, when the second prosecutor of the ICC, the Gambian lawyer Fatou Bensouda, said, "We have enough evidence to conclude that war crimes have been committed by the IDF, but these war crimes are not sufficiently serious to warrant the intervention of the International Criminal Court." And that was the end of the story. Again, the outcome was the same. The victims of that incidents have never received any form of justice. And then we move to another chapter of this long relationship, which is 2014. Why 2014? Another military operation in the Gaza Strip, Protective Age. Again, thousands of civilians killed, just to mention one of the crimes. Thousands of people forcibly displaced, and the list is long. What happened is that Palestine accepted again for the second time the jurisdiction of the International Criminal Court, but this time took also another decision. In January 2015, decided to ratify the statute of the International Criminal Court. So, and was accepted by the Assembly of State Parties as officially as a state party to the ICC. This is an extremely important issue because, as we have seen before, was one of the issues for which the prosecutor had decided not to open an investigation in 2012, and which is still debated incredibly after 16 years today before the International Criminal Court. When Palestine, so we can say at this stage, the state of Palestine accepted the jurisdiction and ratified the Rome Statute and was admitted as such, the former prosecutor Bensouda opened another preliminary investigation. This preliminary investigation was concluded in December 2019 after more than 4 years. In how it was concluded? The prosecutor, the then prosecutor, said, "We have enough evidence to argue that the Israeli authorities have committed war crimes and also that Palestinian armed groups have committed war crimes in relation, when it comes to Palestinian armed groups, in relation to the military operation Protective Age in 2014, while in relation to the Israeli authorities, they have committed war crimes in relation to this military operation in 2014, but also in relation to the so-called Great March of Return, when thousands of people from Gaza, as you know, decided to join every Friday a protest, a peaceful protest, and more than 240 people were killed by the Israeli snipers and thousands were injured at the time. And we have also enough evidence, the prosecutor said, to open an investigation in relation to the settlements in the West Bank this time as a war crime. But despite this evidence, the prosecutor, the former prosecutor, did not directly open the investigation. It decided to delegate this decision, we can say, to the pretrial chamber of the International Criminal Court. In which way? By raising the same question that Luis Moreno Campo had raised before the General Assembly of the UN and before the Assembly of State Parties of the ICC. First question, is Palestine a state under the statute of the ICC? Second, what do we mean for Palestinian territory, which is under international law the territory of Palestine? Both the issues are extremely important. First, as I said, only a state can accept the jurisdiction and ratify the statute, and the definition of territorial jurisdiction is crucial to establish then which is the competence of the International Criminal Court. The pretrial chamber replied to these questions of the Office of the Prosecutor in February 2021 in a positive way. It said, yes, under the statute of the International Criminal Court, Palestine is a state because has formally followed all the procedure, has established it, and has been accepted as a state, as I said before, by the Assembly of State Parties, and so far has acted as a state party. And second issue, for Palestinian territory, we mean West Bank, including East Jerusalem and the Gaza Strip. Which is the outcome, which is the consequence of this, is that every international crime committed on this territory, West Bank, including East Jerusalem and Gaza Strip, falls within the jurisdiction of the ICC. 1 month after, March 2021, for the first time after 12 years, the Office of the Prosecutor officially opened an investigation. But what happened after that was that new prosecutor was appointed, the current prosecutor, the British lawyer Karim Khan, in June 2021. When Karim Khan took office, clearly this investigation, already open, was not a priority for him. And this is testified by a number of elements. No effective investigation was put in place. In other words, no investigators was deployed. But most importantly and concerningly, no budget was allocated in the first 2 years by the office to this investigation, while, and that's more than legitimate, other investigation received huge financial support by the court and also by state parties. The prosecutor started to put in place an effective investigation only after October 2023, when for the first time he visited the Rafah border, which I don't know if you are familiar with the Gaza Strip territory. It's the border between Egypt and the Gaza Strip and the Palestinian territory. And he explicitly talked about the ongoing investigation. This investigation was actually, this first stage of the investigation was concluded in May 2024, when he officially requested publicly, which is slightly in contrast to the previous practice of the ICC, the practice of the other prosecutors, that generally this request is confidential for a number of reasons, according to the procedure of the International Criminal Court. He did it publicly, and he announced on the 12th of, on the 20th of May 2024, the request of arrest warrants against Netanyahu and Gallant, and against 3 leaders, political and military leaders of Hamas. All the cases against Hamas political and military leaders now have been terminated because Israel has killed all of them. The 2 open cases in this moment are the ones against Netanyahu and Gallant, because on the 20th of November 2024, the pretrial chamber accepted and issued, so it's not competence of the prosecutor to issue arrest warrants. The competence belongs to the judges. And in November 2024, the judges issued arrest warrants against Netanyahu, current Prime Minister of Israel, and against Yoav Gallant, former Defense Minister of Israel, for war crimes, including the war crime of intentional attacks against civilians, including the war crime of starvation, which in other words means deprivation of essential goods using starvation as a warfare tactic, absolutely prohibited by international humanitarian law, and a war crime under Article 8 of the Rome Statute, but also for crimes against humanity, which puts the proper attention, focus on the context in which these crimes are committed. The crimes against humanity, for instance, of persecution, is included, or of other inhuman acts. War crime of starvation and crime against humanity of persecution actually means that actually everyone in the Gaza Strip is a victim and can apply to be recognized as such, because these are crimes that affect still today, unfortunately, everyone in the Gaza Strip. So, which are the effects of the arrest warrants? Because generally, as we can see on the media, in particular mainstream media, they try to underestimate the significance. As it has been said before, these arrest warrants against Netanyahu and Gallant are historic. They have an historic importance for a number of reasons. But most importantly, because for the first time, there is a concrete attempt to put an end to the impunity that the Israeli authorities have always enjoyed in this specific context. There is no other precedent in which an Israeli political leader or military leader at the national or international level is under investigation for the commission of international crimes. It's the first time that nationals, political leaders of a country, very close ally to the US and to other Western powerful countries, is under investigation. It's an historic decision for Palestinian victims that I have the honor, together with my colleague Raji Surani, founder and director of the Palestinian Center of Human Rights in the Gaza Strip, and Chantal Meloni, Italian colleague, to represent before the International Criminal Court. Why it's historic for victims? Because Palestinian victims do not have any alternative to the International Criminal Court. The ICC is the only possibility for them to get any form of justice, to express their views, to have a voice at an international level, and also their concerns. Generally, we hear about the existence of an independent and impartial judicial system in Israel. This is not true when it comes to Palestinian victims. It never happened that any Israeli political or military leader has ever been prosecuted by national jurisdiction in Israel, by the military justice system, for the commission of international crimes against Palestinians. We cited before, we mentioned the military operation Protective Age in 2014, despite the commission of international crimes in that context has been widely documented, again, also by UN independent commissions of inquiry. No Israeli political or military leader has ever been prosecuted. Just some soldiers for theft, for stealing a credit card to Palestinian over the Gaza Strip in 2014. That already gives you the idea. And that can be applied to all the other military operations. That can be applied also to the Great March of Return. As clearly documented by the UN Commissions of Inquiry reports, the Israeli military justice system purpose is not to bring justice, but is to shield, protect perpetrators of international crimes when it comes to crimes committed against Palestinians. In other words, the military justice system is an integral part of the occupation, is an integral part of the apartheid regime imposed on the Palestinians. The decision is historic for the International Criminal Court itself, which has been widely accused to be an instrument in the hands of Western countries, to be an African court looking at crimes only committed by African nationals, and for the first time ever, it proves that it can stand, it does not surrender to the pressures of powerful countries, and in particular of the US. It's the first concrete attempt by the ICC to restore its legitimacy and credibility that were at their lowest level, particularly after all the failure to open an investigation in Palestine, as I said before, but also in particular after the very problematic decisions not to put in place effective investigation in Afghanistan, particularly against US nationals, and in Iraq against British troops, again, against nationals of powerful countries. These decisions have created a legitimacy crisis for the International Criminal Court. And the investigation in Palestine is the last, in my views, possibility for the court, the final test bench, to restore such legitimacy and credibility and to show to the world, to the international community, that the court has not been created as an instrument in the hands of powerful states, but to provide justice to everyone, independently on the nationality of the victims affected by the commission of international crimes. The arrest warrants, despite the fact that they are not executed, implemented yet against Netanyahu and Gallant, exactly like in the case of Philippines we are discussing today, or Ukraine, have already produced some effects. Netanyahu and Gallant cannot travel to states that have ratified the Rome Statute, unless, like in the case of Hungary, they decide not to implement the arrest warrants. But this is a serious violation of the Rome Statute. The state parties do not have any political discretion not to implement the arrest warrants. Not doing so means a violation of the cooperation obligation that every state has with the International Criminal Court. And a few weeks ago, Netanyahu was supposed to be in Rome for the appointment of the new pope and decided not to go because of the risk to be arrested. But unfortunately, after the issuance of the arrest warrants, the court has been subject to unprecedented attacks. Of course, by the Israeli government, that has strongly attacked the International Criminal Court, but also by a number of state parties. I'm referring to Italy, Germany, France, Belgium, Netherlands, that have clearly said that they will not implement arrest warrants against Netanyahu and Gallant, and this is a clear, particularly Netanyahu, this is a clear sign of double standards. The same countries have said that they would have implemented arrest warrants against Putin, and that's part of their legal obligation towards the ICC. But they will not do the same when it comes to Netanyahu. This policy of double standards by state parties is again very dangerous for the legitimacy and credibility of the International Criminal Court. But the biggest attack to the court comes from the US administration, from the Trump administration. That not for the first time, this happened also previously with the first Trump administration, but again now, one of the first decisions by the current President Trump was to impose sanctions on the ICC. Sanctions means adoption of an executive order. Executive order, just to make it clear, under the US legislation is an emergency measure which is generally used, sanctions are imposed against individuals accused of serious violation of human rights, individuals accused of international drug trafficking. The paradox here is that sanctions are used against staff of a judicial institution, the only permanent international criminal court. The first person on the list of sanctions is the current prosecutor, Karim Khan, the guilty of requesting arrest warrants against individuals of an ally of the US, as it is explicitly reported in the emergency order by the US presidency. What does sanction means here? It means economic sanctions, all bank accounts are frozen in the US, and means limitation of the freedom of movement. In other words, people in this list cannot enter into the US territory. But it also means something else that maybe is even more concerning, that every US national or company with the legal basis in the US cannot cooperate with these individuals, or if they do, they risk to be prosecuted, and they also risk to be detained and to be sentenced up to 20 years, if I'm not wrong. These sanctions have already produced a number of effects. The email account has been closed because Microsoft does not want to have any risk to be sanctioned by the US administration. US-based human rights organizations have decided not to cooperate anymore with the International Criminal Court. US staff of the ICC has decided not to resign or to just apply for annual leave because of the risk to be sanctioned. But what happened a few days ago is even more concerning, because for the first time, 4 judges, 2 from the trial chamber and 2 from the appeal chamber, have been officially included in the list of sanctions. 2 of them, of the appeal chamber, are guilty, according to the Trump administration, of issuing arrest warrants against Netanyahu and Gallant, and 2 from the appeal chamber because they authorized the investigation in Afghanistan against US national. In any case, unfortunately, it's an investigation that at the moment is frozen by the office of the prosecutor, and so it does not have any effect. Where are we now? And these last 2 minutes exactly I will just focus on this. Where are we now? We are living a very difficult moment for the International Criminal Court, because there is no something like selective sanction. As the president of the International Criminal Court has said in December 2024 at the Assembly of State Parties, there is not something like selective sanction. The sanctions imposed by the Trump administration are a danger, are threatening the existence of the ICC itself, of the entire international justice system based on the Rome Statute. Unfortunately, state parties to the ICC are doing nothing to contrast, to oppose these sanctions. For instance, the European Union institutions, they have the instruments to reduce or to block the effects of this sanction using EU legislation, like for instance the so-called blocking statute or regulation, but they are not doing. The European Commission so far has mainly been silent, or in other words, has declared its support to Israel, and many European Union state parties, as I said before, are attacking the court in relation to the investigation against Netanyahu and Garland. Where are we now? We are at the stage in which Israel formally has decided to challenge the jurisdiction of the International Criminal Court, and this at the moment is at the attention of the trial chamber, that will have to decide once again, after many years, whether or not Palestine is a state under the Rome Statute, and whether or not the Oslo agreements, the agreements between Palestine and Israel, prevent the International Criminal Court to intervene. We can come back to this if there are any questions, of course. And we are at a stage in which Israel is challenging also the admissibility of cases before the appeals chamber in this moment. If the state parties to the ICC will conclude are not going to provide proper support to the International Criminal Court before or after, we will see the concrete effects of the attacks to the ICC. We will see the concrete effects of the sanctions imposed by the Trump administration, and I'm not sure that in the future we will still be discussing about an existing and working International Criminal Court. That is exactly 40 minutes. Many thanks for your attention, and I look forward to any questions. Thank you.
Thank you so much, Triestino, for your overview of the ICC and tracing the efforts of the ICC to bring Israeli leaders to justice, and the historic arrest warrants against Netanyahu and Gallant, and the ramifications of what has happened since then, including the sanctions. I just want to say that you mentioned that you are representing the victims, Gaza victims, before the ICC, along with Raji Sourani and Chantal Maloney. Both of them have presented in prior programs of the People's Academy. So thank you for that. Next, we have Kristina Conti. Kristina?
Yeah, thank you, Marjorie. So for today, I do have a presentation. Good day, magandang araw sa lahat. I will also generally first talk about the situation in the Philippines, or what happened in the Philippines, and then the case of Duterte and some legal issues, and I will end with the issues of victims, both legal and political. Before I begin, I must warn and give you trigger warnings and content warning for blood, gore, and violent speech. I do have a few videos, short videos, and photos. So please be warned accordingly. All right. This is Duterte, Rodrigo Duterte, called the Punisher. He came to power as president of the Philippines from a small town, essentially, the southern capital city of Davao City. He was their own Dirty Harry, and he was tough on criminality and specifically on drugs. I have a few videos and photos, but I will lower the sound in a while.
I would stop drugs and crime, criminality in 3 to 6 months.
So these are scenes from Manila in the first 100 days of Duterte's presidency. Arrests, killings, and thousands of other human rights violations. It was shock and awe, essentially. Duterte wanted to show and do good on his promise, on his campaign promise to, quote-unquote, clean the Philippines. In the same way that he said Davao was essentially cleaned up that was the chief of police of Davao. And when Duterte was sworn in as president, he brought him over, skipping over several ranks. The killings happened everywhere in Metro Manila, but mostly and more peculiarly in urban poor areas. In a little bit, I'm going to show you his pattern and methodology in Davao.
But just give me a little extension, maybe of another 6 months.
So those 3 to 6 months stretched on to 6 years. In 2016, as soon as Duterte was elected, he put in place a policy. And we call this Oplan Double Barrel, or Tokhang, if you've heard that word. It's from the local Visayan dialect. Oplan Double Barrel would have several variations through the years, and it would essentially depend upon public clamor or public feedback from high-profile killings. In 2016, in the early few months of the war on drugs, a South Korean businessman was arrested, taken for hostaged, essentially, kidnapped for ransom, eventually killed, cremated, and his remains were flushed down the toilet in the police national headquarters. This caused an uproar, which was why the policy was tweaked a bit. In 2017, the killings happened in big chunks of one-time, big-time operations. In one of those instances, a 17-year-old boy, the second photo in the circle, a 17-year-old boy was killed, dragged into an alley, and said to have fought back. The police claimed that the 17-year-old boy had a gun on him, tucked in his waistband. He was wearing basketball shorts. Eventually, until now, the operation is Oplan Double Barrel Finale, which is, of course, problematic. Even with the change in administration, they are still following the same system. Through the years, there have been several supranational, national entities that have, quote-unquote, investigated. Well, of course, there's the ICC, which began its preliminary examination, which is the first phase, in February 2018, eventually blooming into an investigation in 2021. You had the United Nations Human Rights Council, which looked into the situation in the Philippines. In 2020, we had the Iceland resolution. Unfortunately, because, and if you look at this, the DOJ, the Department of Justice Review, they had the local Justice Department declared that they will investigate. The UN deferred and said that they will support domestic investigation mechanisms. The local commission on human rights, constitutional commission, which is supposed to check violations of human rights in the Philippines by state bodies, issued a report in April 2022 before Duterte stepped in. Since that we have adopted right time at least 100% um uh, great I'm state and of or had low are with a squad that will straight that killed alleged drug dealers, petty criminals, street children. Listed in 9 and police operations. The killings were identified and so he declares a war on drugs. At one time, he declared a war on the virus, COVID virus. At another time, he declared a war, or he declared that he didn't like people, loiterers. After 3 weeks, 5,000 people ended up arrested. So it's clear that the president's words become part of policy. The identification of the personalities are made publicly with drug lists. Step 2 would be the operation, planting of evidence, a potential reward and quota system, and vigilante killings made Davao Death Squad style. And third, there would be absolution, absolute impunity, either no or poor investigation, and no prosecution. At one point, Duterte even promised pardon to any and all policemen who were caught violating rules or even protocol. This is a CCTV video, short CCTV videos of such police operations. As you've seen earlier, the killings, these operations were also done in broad daylight in the middle of what we call urban poor communities. This is an operation that occurred lunchtime, 12:17 in the afternoon, with men, children, women in the streets. The police were looking for allegedly 2 drug addicts on the drug lists, Rolando Campo and Sherwin Bitas, in Tondo, Manila. And if you look at this video, they commit the killings so casually, as if without protocol. Clearly, if the police are the alleged perpetrator, well, the perpetrators, the investigators, as provided by law, were also identified as the police. So the scene of the crime operations were supposedly or should have been present on site. At the end of this video, as you see, it was physically turned away. And that's what has happened. Absolutely no or very little evidence as regards the killings. The Philippines and the ICC. We joined the ICC in essentially in 2011, but as early as 1998, we had participated in the UN Diplomatic Conference where the Rome Statute was finalized. We ratified the Rome Statute only in 2011. There was a lot of wrangling, problems of internal politics, and differences in policy priorities. But in 2009, in the midst of all that wrangling, our local Congress, the Philippine Congress, promulgated a local or a domestic version of the Rome Statute, which gave Philippine courts jurisdiction over the same 4 core crimes: crimes against humanity, war crimes, genocide, and crimes of aggression. In 2016, the prosecutor makes a statement about the situation in the Philippines and kind of warns that she might consider opening a preliminary examination in the Philippines. In February 2018, she does so. In March, the president declares that we will leave the ICC. Because there's a buffer period in March, the effectivity of the withdrawal only came March 2019. Now, why the ICC, given that we could have also turned to local courts? For the victims of the war on drugs who filed publicly communication and complaint in August 2018, it was clear that Duterte could not be prosecuted in the Philippines at that time. There is presidential immunity in the Philippines, so you cannot file a local case. We were also looking at the expertise and experience of the ICC and the existence of a separate investigation arm. Unlike if we were to file a case in the Philippines, police would have to investigate, essentially, the police or themselves. We also found that the jurisprudence and textual interpretations of international law would be applied in the Philippines, essentially would come from the ICC and other courts and other international tribunals. Now, key issues in the Rome Statute that I would like to discuss here, as the situation in the Philippines opened in 2018, deferral. Article 18 of the Rome Statute provides that within a month of the receipt of the notification, notification that the preliminary examination has been opened, a state has to inform, receipt of a notification that an investigation shall be opened. The state must inform the court that it is investigating or has investigated its nationals. And then the prosecutor's deferral to a state's investigation shall be open to review after 6 months. The Philippines availed of this provision and asked the ICC to defer the investigation. essentially it was appealed. The Philippines lost its case before the pretrial chamber and appealed before the appeals chamber. Some of the key decision points in the appeals chamber included who bears the burden of proof. The appeals chamber said, well, it's the requesting state and not the prosecutor that must prove that investigations are being conducted by the requesting state. The test of admissibility in a situation vis-a-vis a case, still the same conduct, same person test. The Philippines had argued that in a situation, there were no persons identified yet because the identification of the most responsible will come at the time of an investigation. At that time, the Philippines had only finished the preliminary examination stage. What level of information is necessary about crimes charged? Sufficient, not substantial information as alleged by the Philippines. And curiously, the Philippines also threw in Article 19 jurisdictional challenges. And the Philippines said, well, we're no longer a part of the ICC. We have withdrawn. But the majority said, this is not, you have improperly raised the issue of jurisdiction in your deferral request. And with your submission, you are implicitly accepting the court's jurisdiction. The dissent of 2 out of 5 judges said that actually the Philippines has a point and that the court's jurisdiction must be resolved at the earliest possible opportunity. At one point also is, when is the court's jurisdiction triggered? Because the majority said that this is not an issue or a question of jurisdiction at this point. It did not rule explicitly, but the dissenting opinion already pointed out the difference between existence and exercise of jurisdiction, and that the exercise of jurisdiction must be made before the withdrawal is effective. And so we are confronted with the issue, when a state withdraws, does this mean that the prosecutor, and when a state withdraws and the state is at the point of preliminary examination, is the prosecutor required to open an investigation within the 1-year buffer period before effectivity, even if it is not yet ready? In a sense, does it create a 1-year deadline? And we move now to the case versus Rodrigo Duterte, which was triggered because a warrant of arrest was issued, in the sense that Duterte was identified as most responsible for crimes against humanity committed in the Philippines. The warrant was enforced in the same month, March 2025, and it alleges crimes against humanity in the act of murder. The pretrial chamber dropped charges or acts of torture and rape, specifying that these were committed in the context of the war on drugs from 2011, when the Rome Statute was effective in the Philippines, up to 2019. It also pointed out 43 incidents, particular incidents, 19 in Davao and 24 nationwide. We're done with the initial appearance of the suspect on March 14th, 2025. And up next is the confirmation of charges. Now let's talk about the arrest, which should follow Article 59. So Duterte was arrested at the airport in the Philippines after arriving from a political rally in Hong Kong, March 11th, 2025. He had a standoff with the Philippine police, which people thought was ironic because he was given all the due process in the world, which he denied his victims. It's also important to point out, or well, more curious to point out, that the Interpol issued a diffusion notice rather than a red notice, and that the Interpol was allegedly present at the arrest, and that they joined an escort entourage in the transfer and surrender of Duterte to The Hague. Article 59 says that the arrest of a suspect must follow the proceedings of the law of the arresting state. And part number 2, that a person arrested shall be brought promptly before the competent judicial authority in the custodial state, which shall determine, 1, is this the right person? 2, were you arrested in the proper process? And 3, have your rights been disrespected? And 4th, the court has to explicitly tell the arrested person that he has the right to apply for interim release, or in Philippine terms, bail, pending surrender or turnover to the Hague. The Senate, so there is no question essentially yet on this issue raised before the court. So I'm going to refer to a Senate investigation in the Philippines that was made by a Duterte supporter. On the question of whether violations of the law, and I would agree with this, there was no compliance with Article 59 or the appearance before a local court. They also argue that there was a failure to follow arrest processes in the Philippines, which is doubtful, and were there deprivation of visitation rights and other procedural rights, doubtful as well. Apparently, Duterte and his supporters discovered due process this March 2025, but hey. But as to compliance with Article 59, we argue and we see that the Rome Statute has remedies as to violations, and that would be asking for compensation with the ICC. Now, as to the question of, does the Philippines have the legal obligation to arrest Duterte, considering it is a non-state party? There have been mixed opinion as to this, but we always argue that the Philippines has a continuing legal responsibility, obligation to cooperate with the state, considering to cooperate with the ICC, considering that the preliminary examination had been opened in 2018 while the Philippines was a member, and that the crimes were committed while the Philippines was a member. Otherwise, it will just render the membership of the ICC, of the Philippines in the ICC, moot and academic. And so the pending question is, to what extent is a non-member arresting state, or essentially a third party, required to comply with the Rome Statute? Now we come to the meat of the issue of Duterte's, pending defense, which is a question or challenge in respect to jurisdiction. And he makes a distinction between jurisdiction, the existence of it, and the exercise of it. So the Duterte defense echoed as earlier mentioned, the dissenting opinion of the two judges in the Article 18 issue. And while the defense admits the existence of jurisdiction, meaning, yes, the Philippines was a member at the time that the crimes were committed, the investigation, as authorized by the pretrial chamber, happened only after the Philippines had withdrawn from the Philippines. Our counter-argument is that, the preliminary examination by the Office of the Prosecutor occurred before. And we look at Article 59, the exercise of jurisdiction. This was triggered by C, when the prosecutor initiated the request, motu proprio. But here we look at Article 127, which is more relevant because the Philippines has withdrawn. It talks about the continuing cooperation of a withdrawing member. And the key phrase would be, the withdrawal shall not prejudice in any way the continued consideration. And the key phrase is, any matter which was already under consideration by the court. The question now is, does any matter refer to a preliminary examination by the Office of the Prosecutor, or should it refer to formally an investigation sanctioned by the judges? Duterte argues the latter. Under consideration by the court, and the phrase by the court, does the court refer to the Office of the Prosecutor also, or only to the court or the chambers, meaning the judges of the court? of course, we argue the first one, Duterte argues the latter. This is a pending issue before the ICC at present. Parties have already submitted their observations last Monday, and we think that the ICC is well on track to decide on this matter of jurisdiction before the scheduled confirmation of charges in September 2025. Other emerging issues, as was mentioned, the disqualification of judges. Actually, prior to the submission of after Duterte had filed a challenge to jurisdiction, he asked for the disqualification of 2 judges out of 3 in the pretrial chamber, saying that these 2 judges were already prejudiced because they had previously ruled on the Article 18 issue. And this is questionable because how could a judge, essentially, Duterte is asking for a new judge every time an issue crops up. He lost this issue because also last Monday, the plenary of judges, meaning all 18 judges, well, with the exception of 1 who excused herself voluntarily because she had been part of the office of the prosecutor and had participated in the investigation in the Philippines prior. So the plenary of judges rejected the request of the prosecution to disqualify the judges, 2 judges out of 3. Now, many or some of you might have heard that Duterte was recently elected as mayor of Davao City, the same city where he served as mayor for over 20 years. He wants now to round it up to quarter of a century. An issue is whether he would be able to take an oath of office inside the detention facility of the ICC. And pertinent to that would be, would the consular officer of the Philippines be allowed to enter the detention facility for the purpose of executing an oath? And would the consular officer have the authority to administer this oath? Considering, well, would extraterritoriality apply? Another issue which has been very critical for Duterte supporters is, would he be allowed interim release or temporary release, essentially to perform his functions as a public official in the Philippines? There are very limited grounds for interim or conditional release of detainees. And as per review of ICC jurisprudence, none of the ICC has granted conditional release, yes, but only for those charged with Article 70 or the so-called fifth crime prosecuted in the court, but not anybody charged with the 4 core crimes. And also, would it be wise for the ICC to allow interim release or to allow him to take oath at even that, considering they have the experience of Uhuru Kenyatta, who, although he had no warrant of arrest issued against him, voluntarily appeared before the court. He was president of Kenya, but when he went back to Kenya, well, victims suddenly died, recanted their testimonies, and the prosecutor was forced to withdraw the charges against him, or them essentially, because of lack of evidence. Also, how will incriminatory statements, and this will go into his defense, incriminatory statements or admissions be appreciated as evidence, considering there have been many instances that he has admitted to that his sin are just quote unquote extrajudicial killings. As was mentioned earlier, the ICC also has to contend with the impact of sanctions by the U.S. Trump regime. One of the judges who is sanctioned because she issued a warrant of arrest against Netanyahu is also a judge in the Duterte pretrial chamber. But notably, it's not just the US, there's also Russia. Judge Alapini Gansu has a warrant of arrest from Russia because, well, as vice president of the court and as part of the pretrial chamber, she also participated in the situation in Ukraine. Now, how are victims involved? Of course, there's two parts to this. Victims may be witnesses for which the prosecution or the office of the prosecutor is involved. And second, they can serve as participating victims, where they can send in views and concerns to the court as trial continues. But first off, I'd like to note that the victims of Duterte is a whole universe. Oh, and only a portion of that, a small portion of that, would be qualified before the ICC in the case against Duterte. Because one, of the temporal scope, it only covers the first 3 years of Duterte's term. There, in the second 3 years, killing still continued. Duterte also arrested thousands, falsely charged, illegally detained. There were also cases of enforced disappearances. And essentially, as I mentioned, Duterte identified enemies of the state. He not only identified drug addicts, drug pushers, and all those involved in the drug trade as enemies of the state, he also said activists, communists, and terrorists are enemies of the state. And so this entire universe would consider themselves as victims of Duterte. And the ICC case, therefore, is only a narrow spectrum. It's a narrow portion of that spectrum. Among the victim-related issues would be first, essentially, the scope of the case. And the narrow scope, as identified already, those victimized by killings from 2011 to 2019 could very well even become narrower, because if the prosecutor decides to narrow the scope of the case. If you noted earlier, I mentioned that the prosecutor identified 43 incidents of killings. And from what we understand, these are killings that he could prove. He could very well go and say that he's limiting the scope of the case to the 43 incidents. And that will exclude the greater majority of victims and those who can participate in trial and those who can benefit from reparations. And that is prosecutorial discretion. As to registration and representation, an update, victims in the situation as currently defined, victims of extrajudicial killings between 2011 and 2019 can apply until the 3rd of August this year. Only after the registration and admission of these victims can the common legal representative of victims be identified and appointed by the court. That's problematic in the sense because at present, with a challenge to jurisdiction, with a potential challenge, with a potential motion or request for interim release, he's not done that yet, or any other preliminary issues, the victims will be unrepresented by counsel of choice. At present, however, we are cooperating with the Office of the Public Counsel for Victims, which is also part of the ICC. As to remedy, no other co-perpetrators have been arrested, and there are no counterpart domestic prosecutions. At one point, the House of Representatives, the lower house, engaged in an investigation, a full-scale, political investigation or an inquiry into the war on drugs. However, it did not result in any clear prosecution as to the identified perpetrators. There is no other there are no other, and this is sad, transitional justice mechanisms in place. It is as if the ICC is the only hope for the victims of Duterte, period. Not only victims of Duterte's war on drugs. Other victims-related concerns include disinformation. And this photo I'm showing is of Duterte's standee in front of the ICC. That's not him. And it was put up by his supporters who are camping now at The Hague within the area of the jail and of the court. Duterte has a lot of supporters, and I go to the last point of popularity and power of the Dutertes. He was elected by a clear majority as mayor of Davao, meaning he enjoys the support of his people. But he also enjoys high popularity, and at one point, while in office, 90% approval rating. His daughter is vice president. Two of his key lackeys or allies are senators of the Republic. Both of them ran for re-election, number 1 and number 3. They landed in the top 1 and 3 positions. So we have to contend with the sheer power, not only in office, but also in online spaces. The disinformation campaign, with the continuing stigmatization and bullying and intimidation of victims, is significant. Also, myself as their lawyer and at sometimes spokesperson, I am also targeted. These online statements can cross over as physical threats and can constitute security threats. So is the ICC case against Duterte genuinely in the interests of justice? And at one point, we would have to really confront whether the interest of the victims clash with the interests of the general Filipino public. And it's a sobering thought, considering that for us, Duterte's case is one of the I think it's the first time that we had a Filipino president being taken to jail. We had one other president taken to jail on domestic charges, but he was allowed to stay in his own rest house. And 3 days after he was convicted, the sitting president, his vice president before, eventually succeeded him as president, pardoned him of the crime. So impunity in the Philippines is alive and kicking. At this point, as Triestino has mentioned, it would seem as if the ICC is the only hope for the Filipinos for justice. However, we do have to point this out as well, that maybe the ICC needs this case. As mentioned earlier as well, the ICC might have issued warrants of arrest in other situations, high-profile situations, but none of these arrest warrants have been enforced. It was only in Duterte's case. And interestingly, Duterte's warrant of arrest was not publicized. And for us, we thought this was strategy. You don't make it public, but ensure the arrest. Although in the case of the other subjects of the warrants of arrest, it would seem as if it would be impossible to enforce the warrants. So the prosecutor had no other choice but to make them public and name and shame them, essentially. So for us, it's not only Duterte on trial. And for the general international community, it would seem as if the court is on trial to see how they would afford justice, not only for the Filipino people, but to set an example as well as to the rest of Asia. Thank you very much, and I very much welcome your questions later.
Thank you so much, Kristina, for tracing the historic prosecution of Duterte in the ICC and explaining the jurisdictional issues and other pretrial issues being considered by the court, and also the ramifications of this case for international justice. So thank you again for that. Next, we have Beth Lyons. Beth, you're up.
Unmute and. Hi, okay. First of all, I want to thank Dean Cohn for inviting me to speak, and I especially want to thank the previous two speakers. I've been doing work as a defense counsel at the international courts and tribunals for about more or less 2 decades, and I found the presentations extremely both important and cogent and clear, and they really helped educate me. As I said, although I've gone through the Rome Statute countless times. So thank you so much. To begin with, let me just say that in the chat, there are a number of references to what I'm going to talk about, the Onguin judgment. You don't have to go to everything now, but the first reference in the chat are videos of the unsworn statements that the client, Dominic Onguin, made to the court at his sentencing and appeals hearings. And I want to stress, if you read or see or view nothing else, spend some time and take a look at these, because the cases we're talking about involve real people. And very often, as in the case of Mr. Onguin, the client is his own, my view, his own best advocate. Today, I want to discuss this broader issue of legitimacy of the ICC using the Onguin judgment as a lens through which to look at it. As you can surmise from the slideshow, from the very opening slide, I am critical of the ICC's Onguin judgment. And in my talk, I'm going to describe some of these criticisms. But I want to say from the outset that while there are a number of external attacks which have been escalated against the ICC, other speakers have talked to these, there have been also internal areas where the ICC is vulnerable. And this, to me, is one place this is in its jurisprudence. My view basically is that the ICC's legitimacy was eroded by the Onguin judgment jurisprudence, which was based on racial and cultural biases. These biases made it impossible for the ICC to provide an independent, impartial tribunal to adjudicate the charges against Mr. Onguin in violation of his fair trial rights, which is a core concept of human rights and a key underpinning of international courts and tribunals. A few weeks ago, there were speakers at this session who talked about some of these rights and some of the background. My view, in short, is that the ICC should be doing damage control on the Onguin judgment because of its biases and blind spots. And what this communicates to people who come from a non-Western, non-European culture, or from societies which are not dominated by white supremacy, and particularly what it communicates to people who, like Mr. Onguin, are child soldiers, are mentally ill, and who may be disabled. My analysis generally falls under the umbrella of the critique of the third world approaches to international law, TWAIL, and specifically what has been referred to by scholars within this as the, quote, decolonization of international law. And I would point out also that others more expert than I have dealt with the structural racism of the ICC, and particularly the Rome Statute, and the racial inequalities which are embedded within the Rome Statute. In the question period, I'd be glad to give sources on this. I don't have time right now. But what I focus on is how these issues of racism and what I call culturalism impacted on the Onguin jurisprudence. Because at the end of the day, the jurisprudence reflects the thinking, at least of the trial chamber, the holdings of the trial chamber, and what is taken away from the case and used by others. Now, generally speaking, I will make some comments later about my colleagues' views, which I agree with, about the shortcomings and weaknesses of the court. For the purposes of this presentation, let me just mention 3 issues. One, the existence of an ICC policy of selective prosecution. This has already been discussed in terms of the court targeting only persons from the African continent until the arrest warrants for Putin and the arrest warrants regarding Gallant and Netanyahu. But there is also an aspect of this which is selective prosecution of only one side of the struggle, which is what we see in Onguin. Now, unfortunately, the ICC is not alone in selective prosecution, nor is it exempt, as others have talked about, from the influences of the big power. The exceptions, Israel, US, and others who voted against and advocated against the Rome Statute. Now, going to the first slide, which is on the screen right now, most of you may be familiar with the Onguin case. Mr. Onguin was abducted when he was 8 or 9 years old and forced to be a child soldier. He tried to escape many times and eventually succeeded in 2014, and is only before the court in the ICC because he turned himself in 2015 to be prosecuted. He's currently serving a sentence of 25 years now in Norway. Next slide. Mr. Onguin was convicted of 61 charges, including war crimes, crimes against humanity, which included sexual gender-based crimes, and crimes of use of child soldiers and conscripting child soldiers. The Onguin case is a huge case. It's probably in terms of numbers, it's probably the largest so far before the court, especially for a single defendant. It is the first prosecution of a mentally disabled defendant who asserted defenses under Article 31A and D, which are defenses which deal with excluding criminal responsibility based on mental disease and defect and duress. The first case in which culture and spiritualism played a prominent role in the duress defense. As I said, the first case in which a single defendant was convicted of 61 crimes and 2 modes of liability, resulting in the longest judgment, 1,077 pages for the trial judgment, the longest judgment in ICC history. And it's importantly the first case in which a defendant was charged with crimes of which he, the defendant, Mr. Onguin, was a victim, conscription and use of child soldiers. Next slide. At the opening appearance, before opening statements at trial, December 6, 2016, the court asked Mr. Onguin, the presiding judge, Judge Schmidt, asked Mr. Onguin if he understood the charges against him. You can look at this slide later and read it, but please note the last 3 sentences. Mr. Onguin is basically saying, I am not the LRA. The LRA killed people in northern Uganda. the LRA committed atrocities in northern Uganda, and I'm one of the people against whom the LRA committed atrocities. But it's not me, Dominic Ongwen, personally, who is the LRA. This was always a case, in our view, of that it was a case against the perpetrators were the LRA. This was a case against the LRA and its crimes, which the LRA committed under the leadership of Joseph Cohn during the extensive civil war particularly in northern Uganda, but through other parts of Uganda. The temporal jurisdiction for the charges against Mr. Ongwen is a small portion of this, 2002 to 2005. Now, I mentioned earlier, a few minutes ago, the issue of selective prosecution. Take note, although the crimes of the Ugandan People's Defense Forces, the Army of Uganda, of the government of Uganda, were well documented, their crimes including herding people into internally displaced camps, forcibly herding them into internally displaced camps. Although these were well documented and have been called an example of a genocide by Olara Otuno, the former UN Undersecretary and Special Rep for Children and Armed Conflict, the UPDF was never prosecuted. No member of the government. So here's another example of the selective prosecution. Now, next slide, please. Thanks, Erin. The Ongwen case is still one of the, as I said, the largest, most complex cases, and there are a myriad of issues. What we tried to do in the defense in the Ongwen case was to challenge what I describe as the default settings of the ICC in respect to its white supremacy, its racism, its culturalism, and lack of justice for the disabled. Next slide. I wrote a short book about this, which deals with a lot of what I'm talking about today. I won't be able to discuss all of it, but I'm going to try to get through some of the high points of chapter 1, which deals with how these racial and cultural biases impacted the court's rejection of the mental health defense, and also how it affected its rejection, the court's rejection of Acholi traditional justices in its sentencing. Mr. Ongwen comes from the Acholi people in northern Uganda. Next slide. Basically, I start out by saying, look, if the LRA were predominantly white, if it functioned in a predominantly white or European country, if the defense expert psychiatrists who testified for Mr. Ongwen were white, or if Mr. Ongwen were white, I raised the question, would the trial chamber have reached a different conclusion regarding our affirmative defenses of mental disease or defect and duress? My answer is yes. And I believe that Mr. Ongwen would have been acquitted, because I think that these biases and blind spots on the part of the trial chamber were so strong, so permeated, how they heard the evidence, how they assessed our witnesses, how they looked at Mr. Ongwen. Next slide. This is a slide of Article 31 from the Rome Statute, on which we based our defense on 1A and D, grounds for excluding criminal responsibility. Now, next slide. A major point in the defense was that Mr. Ongwen suffered from mental diseases which stemmed from his abduction at the age of 8 or 9 into the LRA, and still continues to this day. What I've listed are the findings of our defense experts and the court-appointed expert who actually, Professor De Jong, who actually agreed with our defense experts, who were Professor Avuga and Dr. Akena from Uganda. You can read all of the details here, but basically it's Mr. Ongwen suffers from depressive illness, dissociative disorders, PTSD, suicide ideation, and other mental diseases. Next slide. The trial chamber basically rejected all the evidence of the defense experts. They said Mr. Ongwen does not suffer from a mental disease or defect at the time of the conduct relevant to the charges. They were looking only at a small period, although people suffer from mental disease for very long periods. The starting point is before the charge period of 2002 and still remains long after 2005. So this gives you some idea of how the judges perceived or conceived of mental illness. But in any case, they agreed with the conclusions of the 3 prosecution experts. Next slide, please. Basically, the judgment, the judges say the methodology employed by the defense experts was deficient. It was outdated. It did not use current scientific standards, and there are a number of other points on this. They're listed, there are 6 points listed on the left of this. I would point out, though, that it was interesting that the prosecution experts, Dr. Metzi from England and Professor Berchtold-Pust from Germany, both of whom were white, and Dr. Abo, who was a Black Ugandan from Makerere, from Uganda. They were 3 defense experts. Now, the only prosecution expert who did not engage in a methodology critique of the defense experts was Dr. Abo, Dr. Catherine Abo. So I want to separate her from the testimony and evidence of the other 2 experts, which is detailed in the book. Now, next slide, please. There were a number of examples of racial and cultural biases, and I'm only going to be able to get to a few of these. I'm watching my time. I want to talk first about number 1, which is psychometric tests and malingering. Basically, the judgment adopted the critique, particularly of Professor Berchtold-Pust, who said that the defense experts were not using, quote, scientifically validated methods and tools. And as a result of this, they concluded that Mr. Ongwen was not malingering. You have to understand that malingering has to do with the veracity of what a patient says. In other words, patients can make up certain symptoms. They can say certain things. They can, quote, pretend to have certain illnesses and communicate this to the professional who is evaluating them for the purposes, in this case, of a court. And basically they said, look, Mr. Ongwen was malingering. You can't trust anything he said. You can't trust any observations that expert psychiatrists from the defense made of Mr. Ongwen. Now, keep in mind, the expert psychiatrists visited Mr. Ongwen, had sessions with him over a period of years, and I would say also that the prosecution did not have did not do that. They were not allowed to by the defense, but nevertheless, reports were available to them based on the defense expert sessions with Mr. Ongwen. So they had the information. Now, basically, the court said the problem is that the defense experts are not using what are called psychometric tests. These are cognitive tests that are used in all sorts of areas, including employment. And basically, in the profession, in the psychiatric profession, these tests have been criticized for decades for their Western bias, for their lack of applicability to countries that are not Western, non-European. These tests are affected by who the person is asking the questions, how the question is asked, and how a response, if given, is interpreted. But essentially, the trial chamber paid no attention to this and said, look, psychometric tests are a gold standard in a psychiatric evaluation. They weren't used. And this was a major way in which the defense expert evidence was deficient, and we rejected. Now, the second example is the layperson criterion and spirit possession. Essentially, the court relied on observations of laypersons who were abductees who lived with or part of the LRA with Mr. Ongwen as a criterion for whether he exhibited behavior which would be perceived as abnormal or somewhat askew, and which would indicate symptoms of mental illness. What they failed to see was that what is perceived as normal, abnormal in a society is determined by its culture, as well as whether these perceptions are communicated by language. Particularly, although we presented evidence that our experts said, look, the conduct that people observe in Mr. Ongwen would be understood within a Choli culture as spirit possession, right? Because of the strength of the religious beliefs in spirits in a Choli land. But they said, no, we don't agree. Similarly, the chamber did not consider the evidence that in parts of Africa, people somatize. It's a psychiatric term which means manifest through physical symptoms. People somatize or express psychological distress as physical ailments. Hence, any lay observations, especially observations by other abductees of Mr. Ongwen's conduct, would not be interpreted as psychological distress or symptoms of mental illness. Lastly, as one of our experts, I think Dr. Akena, pointed out, there's no word if you're asked, are you feeling blue? People from many countries in Africa don't use the term because there's no word in the African language being used in his or her area to express this. All of this is significant in evaluating lay observations. Nevertheless, and next slide, please. Nevertheless, the trial chamber basically didn't factor in these cultural issues, although they're considered by the DSM, which is the Diagnostic and Statistical Manual for Mental Diseases, produced by the American Psychiatric Association, as well as the World Health Organization International Classification of Diseases, the ICD. What the trial chamber said was, it's a trivial issue, as you can see in the first paragraph, right? The fact that there's no word for blues in an African language. And in the next paragraph, 2501, they say that the possibility that witnesses may regard symptoms of mental disorders as spirit possession is immaterial. All we can do is make a judgment on the words, but this clearly indicates what the thinking about culture is and its relation to disease and expressions of disease in the Onguin case and in the jurisprudence which the trial chamber rendered. Next slide, please. The third point that I made a couple of slides ago was the Onguin exception and the role of spiritualism. As I've mentioned, the Acholi people are very spiritual, right? And Cohn is particularly perceived as a spirit medium who communicated through which both the good and the evil spirits communicated to persons in the LRA, especially to the vulnerable child abductees who Cohn targeted. We argued essentially that spiritualism contributed to the threat component in the duress defense under 31(1)(d), and the court said no. We argued that Cohn abused spiritualism. He used it to try to control and cement his power, particularly over children. Now, it's interesting because the judgment, on the one hand, spent at least 30 or so of its paragraphs talking about how abductees were subject to initiation rituals, to standing rules, indoctrination, to a brutal disciplinary regime instituted and carried out by Cohn, but it says nothing about how these factors affected the conduct and mental state of Mr. Onguin. Somehow, in my view, they carved out what's called an Onguin exception. The toxicity, the trauma, the lethal environment of the LRA, it applied to everyone, but not to Mr. Onguin. My view is that this is somehow communicating that Mr. Onguin was, quote, special, that he was able to escape from or immunize himself from the well-known brutality and bestiality of the LRA. And I think this is an example of the trial judgment's racism. Mr. Onguin, a Black Acholi man from northern Uganda, was essentially invisible to the trial chamber. His humanity was invisible to the trial chamber. His individual circumstances, his social context, his cultural context, all were invisible to the trial chamber. And they refused to accept the bottom line that Mr. Onguin also, like the others, abducted and forced into service in the LRA in captivity, were victims of the Lord's Resistance Army. So at the end of the day, to the trial chamber, Mr. Onguin, the person, was just another Black defendant in the dock who was invisible to him. In this slide 13, there's a quote from Ralph Ellison's Invisible Man, a book published in 1952 in the US, written by Ralph Ellison, who was an acclaimed US author, who was African American. The year after the book was published, Mr. Ellison received the National Book Award for Fiction. And he was the first African American writer to receive this award, although books had been selected since 1935 for this award or its equivalency. But I pulled this because it's very clear on the issues of invisibility. The book explores the oppression of Black people in the US in the first half of the 20th century. And the narrator of the book who's described, who talks about himself and his friends and his family and his experiences, he remains nameless. So it deals with this notion of invisibility in many, many ways. Next slide, please. I'm going to skip most of this slide. You can look at it later, but to say that briefly, that the defense had a child soldier expert, a retired major from the Ugandan People's Defense Forces, the UPDF, named Paula Awich, who himself had been abducted by the UPDF's predecessor, the National Resistance Army, in the early 80s. He himself had been a child soldier and now has served on the UN Committee on the Rights of the Children, which is a monitoring body of the Convention of the Rights of the Child, and is an attorney. He basically drew three conclusions. One, being a child soldier never ends. It lasts a lifetime. Even if one is over 18, the age of culpability under Article 26, the effects of being a child soldier endure, and they continue. Mr. Ongwen, as a child soldier, as a person being indoctrinated, did not have, quote, a mind of his own. And these are very, very important. There was some example of how testimony about whether children voluntarily escaped from the LRA on cross-examination. The position of Major Awich was nobody voluntarily escaped from the LRA. There had to be a circumstance, for example, a conflict, a fight. There had to be an opportunity which existed before escape happened. All of this discussion centers on a luo, L-U-O, word for escape. So that this example, at the end of the day, shows how language is incorporated into all of these studies that are done and what it means in terms of the atrocities. Next slide. The principle of complementarity, which both the previous speakers have mentioned, is a cornerstone of the Rome Statute. Here you can see it in the preamble. In the Al Hassan case, Judge Mundua opined that not only does the Rome Statute recognize the plurality of cultures, it places them on an equal footing. My view is that the Ongwen judgment illustrates that the ICC, at least Trial Chamber 9, does not place all cultures on an equal footing. This is a standard to be aspired to, but does not exist, and affects the issue of legitimacy of judgments. The judgment basically negated any role for the Choli justice in the sentencing of Mr. Ongwen. They just paid no attention. They said the information is irrelevant. They rejected the defense motion, which offered to present live testimony from the former Prime Minister of the Care Kwaro Acholi, the Acholi Cultural Institution in northern Uganda, Mr. Ambrose Ola. Generally speaking, the issue of complementarity has been used both at the ICTR and ICC as a principle to be applied in the pre-trial phase, the phase where suspects are tracked to be presented to the various courts. It is not used in the sentencing phase. And I think that complementarity needs to be applied to the sentencing phase and should not only be relegated to a pre-trial phase. Next slide, please. In the book, there are a number of remedies. I don't have time to go into all of them, but I just want to talk about Article 78 and Rule 145, which are here, determination of sentence. I'm proposing, as others have proposed, that culture should be part of the individual circumstances of the convicted person and should be considered for the purpose of determination of sentence. As you can see, individual circumstances are highlighted in Article 78. At the same time, the traditional justice mechanisms, which vary from country to country, people to people, on the continent, but also in other parts of the world, should be included in Rule 145, which implements determination of sentence. In addition, I'm advocating, as you can see on the right, that factors such as race, culture, religion, and disability as individual circumstances should be included in Part 145C in the statute. And next slide, please. Basically, I've argued that the ICC has to look at its judgments starting from the beginning and identify, assess, and evaluate the extent of the problem of racial and cultural biases in its judgments. Not every judgment is the same. There has been some limited recognition and weight given in a few judgments prior to Onguin, and I go into those in the book. But basically, the court is able to, under Article 84, revise convictions or sentence. I'm proposing that this new criteria dealing with racial and cultural biases be implemented. And that a particular attention be paid to Article 21.3, which says that the court, whatever the trial chamber is, has to apply and interpret the law consistent with internationally recognized human rights instruments. I think an argument can be constructed based on an interest of justice jurisdiction of the court to do this. But this is just an example of one of the remedies for the problems that I've identified. In the last few minutes, I have about 2 or 3 minutes, I think. I want to conclude. The question I ask at the end of the book is it, quote, just biases and blind spot, or is it legal racism and culturalism? I believe that it really is a legal racism or culturalism where the court does not either pay attention to, give appropriate weight to, or outright dismisses issues regarding race and culture. I say this because the court's judgments do not exist in a political vacuum. We've heard about from the previous speakers how politics interact with the judicial proceedings. I mean, that is the subject of a whole year's worth of seminars. That's the reality of the world. But my position is that the default settings, which were apparent in Onguin of white supremacy and Western cultural norms, have to be challenged. And this has to be done by the ICC. This matters not only for the defendants who are affected by the jurisprudence, but also for the victims as well. And parenthetically, I would add that victims and defendants are often from the same communities. That's another topic, but I think it's important to note that. I understand that trial chambers render independent judgments based on the trial chamber. There's no stare decisis, so to speak, that chamber 1 has to follow chamber 2, etc. Judgments at the appeal level are different. But I argue there has to be some kind of universality for fairness and impartiality in the judgments, And that's really what I'm talking about. The Onguin judgment sets off alarm bells, as I said before, for defendants who, or potential defendants who may be child soldiers, mentally ill, disabled, people from non-Western cultures and countries, that they will not receive a fair trial if the ICC were to adjudicate the cases. I think the Onguin judgment particularly is important because it was an or it still is an opportunity for ICC jurisprudence to make a significant contribution to international criminal law. But I also think the ICC has squandered this opportunity. And what in fact has happened is that it has tragically dug the grave of international justice even deeper. I want to underscore this because I say tragically because it's particularly with the escalation of the US attacks on the ICC that the first speaker spoke about, with which I agree. I would point out that these have been going on for almost 3 decades, since the PrepComs in the late 90s before the Rome Statute. The arguments of the majority against the majority of those present against the US and Israel, who fought against the inclusion of forced deportations and forcible transfer within crimes against humanity and also war crimes. So the US and Israel have been attacking the ICC for it's going on 3 decades at least, more or less. Now, some people may be asking, well, the ICC and clearly international law is under attack. Its very existence is under attack. So why are you raising all of these, quote, internal criticisms of jurisprudence now? Doesn't that undercut support for the ICC? My answer is it doesn't. I support the ICC, but I support an ICC that is fair and that is inclusive and that fights against its own biases and its own blind spots. And I think this is necessary. I mean, I think that the ICC is at a point where it's losing support from a number of the original states parties, particularly in Africa, who were in the forefront of the preparatory committees and also the eventual passing of the Rome Statute, ratification of the Rome Statute. So I think it's very important that the ICC hold on to whatever is left of its support, but it absolutely it has to focus on its legitimacy, and it has to fight for it on many fronts. Thank you.
Thank you, Beth, for your critique of the ICC through the lens of the Onguin case and your explanation of his defenses of mental disease or defect, duress, and cultural abuse. I'm anxious to read your book. And I want to thank all of our presenters for their clear and provocative presentation and for sticking to their allotted times to give us plenty of time for questions and answers. Before I get to some of the questions that have been asked by attendees, I would like to give our 3 faculty members an opportunity to respond to each other's presentations, comment on them, or raise questions. So Triestino, Kristina, and Beth, please feel free to chime in and comment on each other's presentations, or even raise things that you thought of during the presentations.
I might have just a question for Kristina, if you allow me. which is not really strictly legal, is more political. I mean, I was wondering, after the withdrawal from the Rome Statute by Philippines, what's the situation now? I mean, politically speaking, in relation to the support and cooperation with the ICC, and whether there is a possibility, that that decision is. I mean, the different decisions are taken by the current authorities, considering that there has been a sort of cooperation with the court in this in more recent times. I'm just curious of this. Thank you.
All right. In response, so first I've mentioned that the Dutertes are sorry. So first, I have mentioned that the Dutertes are still very popular in the Philippines. They're in power, more importantly. Now, here's the thing. There seems to be a compartmentalization in that the Dutertes are popular, but the people generally support the ICC proceedings. In fact, at one time, while Duterte enjoyed himself personal high popularity, the people in a different poll would say that they were concerned about extrajudicial killings. So I think that's an issue that we need to resolve within ourselves, whether we understand our politics really well, that these people actually represent extrajudicial killings and rights violations. And it also reflects on his daughter as well. The daughter is facing a similar accountability mechanism here. The daughter has been impeached by the lower house and is facing the impeachment trial in the Senate, but still enjoys the confidence and trust of people. So that kind of compartmentalization in people's minds is very curious, and I myself, I cannot explain that. But as to, and here's the thing, the Philippines is a deeply divided country in terms of socioeconomics. If for many, our socioeconomic system is, or for many, the socioeconomic system would be an inverted or a triangle. Here in the Philippines, it seems now it's a tack with a larger base of poor people and the powerful and the rich as in on top. Problem is with the Dutertes, they have the support of everybody across that range. But there is also a formidable force, although not the majority at this point because of the elections, because of the election results. There is a majority that is gearing up now. And in fact, we're at a crossroads. The impeachment trial of the daughter, Sara Duterte, has been obviously sabotaged. Just today and yesterday, there were demonstrations for accountability. And in a country where we've seen two people powers, well, peaceful quote-unquote revolutions, it seems likely that we will have a third one, where a gathering of mostly middle class and even basic sectors would pour into the streets to oust, well, Marcos, who's the sitting president, in protest of both his actions and of the sitting vice president's actions. So we're at a real crossroads. And if I may just add, it seems to add kindling to the fire, so to speak. Duterte just filed a motion or a request for interim release. We're likely seeing the issues of the daughter and the father come together. And as regards our politics, a lot to be seen so far, but people are angry. And as we've seen, that anger could very well turn into something that would spark a revolution.
Triestino, I have a question for you, but I just want to preface it by saying that I think it's implicit in our discussion today, but I just want to lay it out for people that the difference between the ICC and the ICJ is that the ICC is a criminal court that actually brings individuals before it and tries them and has the ability to punish them, whereas the ICJ, the International Court of Justice, which is the judicial, as you said, the judicial arm of the United Nations system, deals with conflicts between states. And so, in light of the ICJ's decision, and the ICJ's finding that there was a plausible case of genocide by Israel in Gaza, why do you think that the ICC prosecutor did not include the crime of genocide in the arrest warrants for Netanyahu and Gallant?
Well, of course, selecting, identifying the cases, which means the individuals allegedly responsible of international crimes and the charges and the crimes of which they are accused, falls within entirely the discretion of the office of the prosecutor or the prosecutor himself. It's part of his discretion under Article 53 of the Rome Statute. The prosecutor has always made clear in this investigation that he will go where the evidence leads him. So if there is evidence in relation to a crime, he would have opened the investigation. Unfortunately, as you correctly say, this did not happen in relation to the crime of genocide that is actually widely documented. The International Court of Justice, actually the first time on the 26th of January 2024, said that it's plausible that Israel is committing genocide, and then on two other occasions. I think that the answer to the question is that the prosecutor, from a legal perspective, doesn't believe to have enough evidence to charge anyone in this investigation with the crime of genocide, which, to be honest, from my perspective and also victims that I represent, it's very difficult to understand from a purely legal perspective, because I think that for the first time since the situation in Rwanda, there has never been so much evidence in relation to the commission of genocide. I'm referring in particular to what is usually not the most difficult element to prove when it comes to genocide, which is the special intent to destroy in whole or in part a protected group. Well, in this case, like discussed before the International Court of Justice, there are hundreds and hundreds of statements by Israeli political and military leaders showing a clear intent to destroy Palestinians. I mean, I can refer to really a long list of statements by the same Netanyahu, the president of Israel, Herzog, Gallant, Smotrich, Ben-Gvir. All of them are senior officials who now explicitly talk of ethnic cleansing of Palestinians in the Gaza Strip. The current scope of the investigation is not definitive, which means that the prosecutor can still widen or reduce the scope of this investigation. Victims' expectation is that he's going to widen the scope of the investigation, first of all by including the crime of genocide, but not only. There are also other very well documented international crimes currently being committed in the Gaza Strip that are not part of the investigation. I may mention, for instance, the forced displacement of almost 2 million of people where there is no safe place, and forcible transfer is both a war crime and a crime against humanity, and can also be, according to the ICTY jurisprudence, a genocidal act. I refer to the widely documented torture against detainees in the Gaza Strip by the Israeli authorities, just to give some example. Why they are not part of the investigation yet, this is difficult from a legal perspective to understand. If the principle is that the prosecutor goes where the evidence leads him. But please let me also say that the scope of the investigation is also narrow because it does not include any crimes committed before the 7th of October. And that's particularly concerning for the victims we represent, because it gives indirect legitimacy to the rhetoric that everything started on the 7th of October. And while, as everyone knows here, The commission of international crimes in Gaza Strip is widely documented even before, as I tried to say. The same applies to the West Bank, including East Jerusalem. Why there are no charges yet related to the commission of international crimes in the West Bank, including East Jerusalem, is difficult to understand. I was mentioning settlements as a war crime and as a part of the investigation opened by Bensouda. I personally believe, although I don't represent victims from the West Bank, that settlements, the transfer of civilians from the occupying territory to the occupied territory, is the most documented war crime in the world because all the evidence is public, including the names of the alleged perpetrators of this crime. So, to answer to your question as well, the expectations of the victim here will be that the prosecutor is going immediately in the near future to widen the scope. Widen the scope means at least including the crimes I was mentioning, but also including other individuals. It's difficult to understand how no senior official of the IDF is currently subject to any arrest warrants. How is it possible, for instance, to charge political leaders of intentional attacks against civilians without involving the army? Again, this entails the risk to provide indirect legitimacy to a dangerous narrative, which is that this is the moral army, which just comply with orders of two bad apples in a country, which is actually does not reflect the reality in this specific context.
Thank you for that, Triestino. I have a very brief question for Kristina regarding the issue of the interim release of Duterte. You mentioned that there is a fifth crime in the Rome Statute for the ICC. I've never heard of that before. Could you tell us what it is?
Oh, Article 70 deals with offenses against the administration of justice.
Okay.
And it would refer generally to tampering with evidence, victim intimidation, and so forth. So the two so far, according to my research, two accused in the ICC who have been granted release were charged only with Article 70 crimes, Gigeru and in the Bemba case. All others who have been charged with the 4 core crimes have not been granted interim release. I just briefly scanned the interim release request of Duterte, and it's concerning to me, and I have to check this again, that the prosecutor apparently has been in talks with the defense, and that the prosecutor has intimated to them that they will not oppose the release of Duterte. Now, as a general principle, pretrial detention is frowned upon. But of course, in the interest of the victims, as I just tweeted, for the victims, any form of special treatment for Duterte adds salt to the injury. And the fact that he enjoys the due process and rights of normative rights of the detained, that he enjoys this, really is an insult to their victimization. And so we would have to discuss further. But I would say that on the part of the victims, this is certainly sobering. It's like a cold shower. But we do understand and appreciate that Duterte is applying for interim release on humanitarian grounds. But we would have to study this, considering that his release could pose a challenge or even a threat to witnesses who have not yet even been identified in court. So we'll keep you updated as to this development.
Okay, thank you. I want to turn to the questions from our attendees, but preface it by saying that The day that Netanyahu arrived in Hungary, and Hungary is a party to the Rome Statute with a duty to effectuate his arrest for the war crimes and crimes against humanity, Orban, the president of Hungary, withdrew Hungary from the Rome Statute. The problem is that that doesn't take effect for a year. So his country is in violation of the Rome Statute. And also, I wanted to point out the double standard of the United States, who, although they've done everything they can to undermine the ICC, when the ICC charged Vladimir Putin and another Russian official with war crimes, the U.S. was cheering, and yet the U.S. has done everything it can to undermine the court vis-a-vis its prosecution of Netanyahu and Gallant. And that brings me to one of the questions from our audience, and that is, if the European Union doesn't counter the US sanctions against the ICC, then how can it face the Ukraine and Russian war crimes? Do any of our faculty want to respond to that? I think the question itself kind of contains the answer, but if anybody has a comment, you're welcome to weigh in. Okay, we have another question that is directed to Kristina, and that is, if Duterte was granted interim release, could he be rearrested in the Philippines? Could the ICC try him in absentia without the power to enforce its judgment with penalties? And also, what is the likely role of the US in promoting his release and preventing prosecution? And I think that you may have kind of answered that by saying that prosecution is not opposing his release. Presumably, the court would still have jurisdiction over his case. Is that correct?
Yeah. So I'll answer the middle part of the compound question. So is the here's the thing with Duterte's release, the receiving state has not been identified, and this will play into the answer essentially, because if the receiving state would be the Philippines, meaning he would be returned to the Philippines, and probably he would serve as mayor of Davao, then it will signal a significant shift in politics. I must also emphasize that although the Dutertes and the Marcoses, Marcos ran as president, Duterte, the daughter, ran as vice president, came together and formed a unit team, and one ran away with majority of the votes in 2025. They split up recently, which is why people believe that the arrest of Duterte and the impeachment trial and the charges against the vice president, Sara, are politically motivated. When Duterte returns to the Philippines, it would certainly signal a shift in the circumstances, because it would assume and it would say that the Philippines, through President Marcos, is welcoming him back. The arrest of Duterte cost him a lot of political capital. And it showed in the recent elections where the administration candidates did not secure so many seats and so many votes. So there's a lot of politics that plays into it. And that's correct. The US, as it appears, also has a lot of interest. In fact, the Philippines is explicitly mentioned in the executive order issued by Trump, because, and as it seems, we're on the same level of friendship as Israel. The Philippines and the US have a mutual defense treaty signed in 1951. And we were among the countries that are identified as friends or allies of the US. And in fact, we who are working on the ICC case in the Philippines, assisting the victims, could very well fall within the scope of these sanctions. But to point out again, the sanctions only concern travel restrictions and property blocking at this point. Although it's concerning that the prosecutor has already raised concerns about his inability to access his email accounts. And presumably that would be an email service provided by a US company. But from what we see, there's a lot of players as regards politics, because on another front, there's also China, whom we are at odds with in terms of territory, as in literally. We have an issue about the South China Sea, which we would like to claim as the West Philippine Sea. So there's a lot of interests at play, and it's really a delicate balance. What the victims have to understand and are trying to point out here is that regardless of these politics, the interest of justice calls for the prosecution of Duterte, actually, whether at the ICC or in the Philippines. We are not close to that possibility. But at this point, as has been earlier stressed, it would seem as if the ICC is our only chance, however imperfect as it may be.
Okay.
And as to the arrest,
Great.
that depends on so many things, but I have to note that the person or the police officer who caused or effected the arrest of Duterte is now the chief of police in the Philippines.
Interesting. Interesting. Okay, thanks for that. Beth, there's a question for you. In your defense in the ongoing case, did you raise the defense of lack of capacity to form the intent to commit the crimes due to mental disease or defect? I think we might have lost Beth. Maybe we can come back to that. Here's another question. What can individuals and civil society do to support and ensure the continuation of the ICC at this crisis of US actions against the court in response to Israel's crimes in Gaza and the resulting arrest warrants? Any of you?
Well, there are plenty of things that civil society organizations in different countries can do to support the work of the International Criminal Court, which I think first of all means to exercise pressure on their governments, authorities to comply with their legal obligations under the Rome Statute. We have seen, as I was mentioning before, a long list of state parties to the ICC that have officially said that they are not going to comply with the arrest warrants, with binding judicial decision. So first of all, I think the mobilization we are seeing, particularly in these past few weeks, should also include pressure to comply with the international obligation, which of course means the ICC, but also the binding decisions of the ICJ we were mentioning before. Civil society organization can also put in place domestically legal actions, present evidence, which is also public, open source evidence to national authorities, national courts in relation, as many groups are doing in different countries, against Israeli allegedly involved in the commission of international crimes in Gaza. They can support the proceedings also by indirectly by providing support, any type of support to Palestinian civil society organizations that have been working for more than 15 years now with the International Criminal Court. I refer to the Palestinian Center for Human Rights in Gaza, Al-Mezan in Gaza, or Halak in the West Bank, just to mention some organizations. Without them, it would be really unthinkable, difficult to imagine an investigation at the ICC in this context, where, as I said, no investigator officially from the ICC has ever put has ever visited Israel or the Palestinian occupied territory. If you allow me just 1 minute in relation to the question before that has not been answered, I mean, more than a question, I think it's a comment. Then, of course, if the ICC, the European Union is unable to react to the sanctions, how can the EU, I think, be credible when it puts in place its strong commitment to international justice in other contexts? We have seen how the EU has been very vocal in relation to the situation in Ukraine, also supporting the creation of a special tribunal with competence over the crime of aggression. Of course, if you then promote a policy of double standards, you invoke for justice, and that's great in Ukraine, but then you attack justice, so you don't support justice, you stay in silence in front of the attacks. Of course, this is again a clear policy of double standards that it's not in action, actually, it's also an attack to the court itself, and is what makes the court very weak. And this goes back to the point of what civil society can do, especially in Europe. Civil society can make pressure on European Union institutions, firstly, in relation to the Trump's sanction. The EU, as I said, has legislative instruments to reduce at least the impact of sanctions. Human rights organizations, individual civil society organizations in general should make the European Union accountable on this and ask why the European Commission, asking individual MPs why they don't pressure the European Commission to use this block legislation to reduce again the impact of sanctions.
Okay, thank you for that. Beth, did you raise the defense of lack of capacity to form the intent to commit the crimes based on mental disease or defect?
Yes, thank you for the question. I abbreviated the defense, my explanation in the talk, but the Article 31 states that a person suffers from mental disease or defect, which destroys a person's capacity to appreciate whether whether the unlawfulness of his conduct and impedes his capacity or control of his conduct to conform with the law. I'm sort of paraphrasing it here, so that it's implicit in the defense mental capacity. We argued that basically Mr. Ongwen had a childlike mentality, that his sense of right and wrong was cut off once he was abducted. Whatever he had learned from his parents, and his father, I think, was a catechist, whatever he had learned was totally erased and replaced by the LRA and its indoctrination. So that's the issue of, thanks for pointing that out. That's the issue around the defense. So the answer is yes.
Okay.
If I may, I just want to make a few brief comments on a couple of questions ago.
Yeah, go ahead.
Okay, I think that, I don't know, I think there was a question about Israel and the prosecution, and I just want to say that I agree with Triestino's presentation that it's the arrest warrants is a huge step for the prosecution. But as you and he and others have pointed out, genocide was excluded, but also the crime of apartheid. And for me, I would maybe express this more harshly. The only requirement for the prosecution before he or she should initiate an investigation is a reasonable basis. A reasonable basis. Now, admittedly, that's subjective, and I've never seen the prosecution evidence in terms of the crimes of Israel and Palestine. But that's a low threshold. It's not the threshold at trial. So I really strongly would raise the question of what happened. And my view is that we have to look at these positions, like the prosecution, from a political viewpoint as well. I don't know the prosecutor's politics. I'm not making individual comment about this, but these are also political positions, and And I think that the assessment of political will from quote countries that count is an important factor in making assessments. And unless we think of that way, it's not possible to just deal with the law on legal terms as specified and elaborated in the Rome Statute.
Great. Thanks for that. There's a question, is there any way the ICJ can penalize a state party to the statute for refusing to comply with an ICC arrest warrant? And how many states parties to the Rome Statute have withdrawn from the statute, and have any withdrawn and then ratified again? Any of you want to tackle that question?
I can try to answer the ICJ question, and to the extent of my knowledge, there is no state that has withdrawn and then re-ratified. There was a process of withdrawing from the Rome Statute in South Africa, but then fortunately this was changed, and South Africa withdrawal will never become effective. So the answer to the first question is no, the ICJ does not have any competence in relation to violation of the Rome Statute by state parties. The procedure here before the ICC is very clear. What happens if a state, like Italy has done a few months ago in relation to the Al-Masri case in Libya, accused of crimes against humanity against asylum seekers in Libya, has not implemented Italy the arrest warrants, or as Mongolia has done with Putin, or a few African states, including South Africa, have done with Omar al-Bashir, at the time president of Sudan, not complied with arrest warrants. The procedure before the ICC provides this. So there is a decision by the competent pretrial chamber establishing that the state has violated the Rome Statute. Then the pretrial chamber refers this violation to the Assembly of State Parties. It will be up to the Assembly of State Parties to take a decision, to issue a resolution, and to sanction the state that has violated the Rome Statute. To the extent of my knowledge, this has never happened. In other words, the Assembly of State Parties is quite shy. States are quite reluctant in imposing any sanctions or in condemning decisions by other states. Of course, the ESP is a political body, and there it's really unlikely that this is going to happen. So it's generally where this procedure stops. There have been so far, at least again, to the extent of my knowledge, strong condemnation by the ASP when a state has clearly violated its obligation under the Rome Statute. All this procedure does not involve the ICJ at all, are different bodies, and they are not bound by the decisions of the other one, or the violations, of course.
Okay, thank you, Triestino. And for our last question now, Triestino, you did mention when I asked why there wasn't a charge of genocide in the arrest warrants against Netanyahu and Gallant, and you talked about prosecutorial discretion. This is a related question. Why is what the Israelis are doing to the Palestinian hostages in their torture dungeons not part of the crimes and crimes against humanity that are alleged against Netanyahu and Gallant?
Well, I think the answer is the same as before. I was also mentioning torture as widely documented crime, war crime, crimes against humanity. So it's part of exercise of prosecutorial discretion. Now there is more evidence. There is also a very detailed report by the Palestinian Center for Human Rights published a few weeks ago on this. So the hope is that the prosecutor is going to include this in the charges. But we should not forget that the use of torture is widely documented in the West Bank as well, including East Jerusalem. So, and just yesterday or 2 days ago, the Trump administration has designated as terrorist one of the main human rights organizations in the West Bank when it comes to the protection of fundamental rights of prisoners. This organization is Adamir, so you can really see the paradox here. Human rights groups are treated as declared illegal as terrorists, while the responsible of international crimes are supported and enjoy impunity. This is really well, at least the paradox we are facing today.
Right, right. And I just want to add one thing, that although the war crimes and crimes against humanity alleged against in the arrest warrants against Netanyahu and Gallant include starvation as a war crime, certainly the court will consider what has happened since those arrest warrants have issued, particularly since March 1st, where Israel adopted a conscious policy to basically starve all of the people in Gaza to death. And so I think we can see that they will also consider that evidence as well. In the remaining 2 minutes, does anyone want to add anything? Any of our faculty members? Okay, well, this has been a wonderful program. I want to thank you all. Oops.
Yeah.
Marjorie, sorry, I'd just like to thank, of course, the Dean and the People's Academy and IADL. And I'd like to appreciate the presentations of Triestino, especially as because the Palestinian situation was, the investigation into the Palestinian situation was opened roughly at the same time as the Philippines. And so we were closely monitoring both. And at one point, we were figuring out the priorities of the prosecutor. Of course, we would have to defer to the decades-long preliminary examination into the Palestinian situation and are learning greatly from the discussions as to jurisdiction. Beth's discussion was, I appreciate as well, because if you must notice, in Duterte's case, there is no clear defense aside from the issue of jurisdiction. Aside from that, what else has he left to say? Except, and we think this, he might allege that he's insane and just had lucid moments while he was serving as president. Because essentially what he did was indefensible, and you have all these statements coming from him, directly from him, instigating the killings. And so we're learning from all of these cases. And I think the track would be really to come together and compare these circumstances, these examples, and lift where we can learn from each other. So I thank you again, everybody, for this discussion. And good morning from the Philippines.
Yes, it's 3 a.m. Thank you so much for joining us, Kristina. And thank you to all of our faculty, to our interpreters, to Aaron, our administrator, and to all of you who have registered for this course. The next program of the People's Academy of International Law will be a seminar on the right to peace, a legal and political perspective. It will take place on Monday, July 7th, and the faculty would include Carlos Villan-Duran, June Sasimoto, and Richard Falk. So hope to see you all there. Thank you so much.
Thank you very much. Bye.